This is Arkady Frekhtman, a New York City personal injury trial attorney, and today we're coming to you from our office in Brooklyn, having just finished a jury trial where we got an excellent result for a deserving client who sustained, unfortunately, a serious life-changing injury. So how did we do it? Let's break down this case. Basically, the case involved a girl who was 13 years old. And when she was 13, she visited a friend whose parents owned a manufactured home in upstate New York in the Loch Sheldrake area. So her friend, and a few other kids, maybe 3-4 kids, were playing tag in the grass. And suddenly, our client felt a sharp pain. And she said, "What's going on?" And she looks down and she sees her entire sneaker covered in blood. What had happened was there was a broken pipe in the grass that she couldn't see because there was no lighting. It was dark after 9 p.m. at night. And, you know, it was a cast iron jagged pipe that was broken. So it cuts her ankle. She runs to the house of, you know, her parents, her friend's parents. They take her to the hospital. In the hospital, they give her 8 stitches and they send her home. Then like about 3-4 weeks later, she goes to a hospital in Brooklyn where she lives. And at that hospital, they remove the stitches. And then maybe in November, this happened in July. So in November, about 4 months later, she goes to another hospital and she just says, "Look, I'm concerned about the cosmetic appearance. Is this scar gonna go away?" And they look at it and they give her some recommendations. And each of these hospital visits is only like, you know, for 2 hours, maybe 1 hour, just a quick hospital visit, going into the emergency room, going into the hospital, and then going home. And so then later in 2019, 3 years later, after this July 2016 incident, 3 years later, she goes to just a general neurologist, somebody that I think her mom found, just somebody in Brooklyn, general neurologist. He takes a look at her and he says, you know, most of these tests are normal, everything's fine, but you may have like a superficial nerve injury because she is complaining of some pain from non-painful stimuli, such as when you take a shower or when she's putting on her jeans, like the edges of the jeans will touch the scar and give her pain. So he says this is known as allodynia, pain from a non-painful stimuli. You shouldn't be having this. But he pretty much like writes it off, right? And then in 2022, in March of 2022, she goes to another neurologist who's actually our expert. And then this doctor does more of a detailed, deep dive and really looks into everything. And he does something known as electromyography through sympathetic skin response testing. And it shows that there is decreased nerve conduction in the left ankle. He also does a temperature check with a skin thermometer, and he sees that there is almost a 1 degree Celsius difference between the left ankle and the right ankle. And she's got the permanent scar, about a 5 centimeter, 2-inch scar. So how did we do this case? How did we win it? So first of all, we were preparing the case on both liability and damages. The entire time we litigated this case for 6 years, the defendants were telling us that they thought we would lose on liability because they said, look, first of all, in the deposition, she was a kid, you know, she's 13. She didn't testify so well. She said, "I'm not sure why I fell, I just slipped." They said, "Well, did you see what caused you to fall?" She's like, "I know, because it was dark." "How did you know that it was the pipe?" "Well, the next morning we went with some adults and we looked and we see there's a broken pipe. But how do you know that's the pipe that caused you to fall?" So they were really trying to dismiss this case on summary judgment. Now, we beat the summary judgment motion and we kept the case alive. But, you know, admittedly, there were some issues with liability. So then when the case was coming up for trial, we tried to settle the case. And they said, "Okay, we'll give you $25,000. I'm like, "No, that's way too low. We'll give you, you know, $55,000. "No, that's still too low." Then I think their top offer was like $85,000. And off the record, they said, "Oh, we could get you $100 maybe." So this was a big fight on liability. So what we had done is we had done a little bit of a deep dive into this community. We researched it online and we actually found out some really, really damaging information. First of all, they had known that they had a lot of problems with their water system. They had like sewage, they were backed up, water was not working. This was like a trailer park community of these manufactured homes that were, he was selling home sites. The whole place is like 4 acres and there's 320 different homes. But the owner was really being cheap. And and then we found this one guy who was a former employee who was actually the property manager who's in charge of managing the whole, enchilada. And he was going to be like singing like a canary. He was like, look, I'm going to tell you. And he seemed very, very, truthful, this guy. He just said, look, I can tell you what's really going on. And then we found out through doing Freedom of Information law searches that the Attorney General was actually filing a lawsuit against this place. There was this whole thing. And then we find out that the guy who owns it was like friends with some lawyer in Florida who was on American Greed, who was like some kind of shyster who got convicted of $150 million Ponzi scheme. So this is a mind-blowing story. So anyway, but what happened was when we came in for trial, we were ready to go on liability and damages, but we had some issues. Like one of our liability witnesses just happened to be on a cruise. So he's on the cruise in the Caribbean. So we're like, how are we going to get this guy? Maybe through Zoom, he could be like on the cruise ship, like testifying for us. But it was, we might lose that witness. The other witness, who was the former employee, was also in another state, and we'd have to do his testimony through Zoom. He wouldn't be able to come to court. So then the defendants, on the very, very eve, like right when we say, look, we are going to pick a jury, and when the judge says, okay, go out and pick a jury, at that point they tell the judge, you know what, judge, we're going to concede liability, and we're just going to do the trial on damages. So we think, well, okay, if they're going to concede liability, great. So then that, resolves all those issues. Although I was kind of like upset because I wanted the firepower. I wanted all those fireworks, all that bang, bang stuff about the guy being, on American Greed, $150 million Ponzi scheme. There was another thing that we found out, that basically they had like 30 of these pipes broken all over the 4 acres. And they actually had an excavator machine from a local equipment place. And so, it was there already, right? And it was going to repair the broken pipe. But the machine just cost like $400 a week. And the owner of the entire complex was like, I don't want to pay $400 a week. So then the company comes and repossesses the machine and takes it back. And that's why the pipe didn't get fixed. And the property manager was going to testify, if he was allowed to testify by Zoom, that, he knew about this for 2 years and the machine was already there to fix it. And he just chose not to pay. And for 2 years, he just, is just like this terrible landlord. So, that was one of the issues. But anyway, so they concede liability. So now we're picking a jury. And then in the voir dire, I ask the prospective jurors. We have a panel of about like 15 jurors that we're speaking to. We have a room of about, actually more, we have a room maybe of like 30 jurors. But what we're doing is we're seating 8 at a time, because in New York, you have 6 jurors and you have 2 alternates. So we're seating 6 with the 2 alternates, and we're talking to 8 at a time. So as I'm talking to them, I'm talking to them about their ability to allow for damages. And I say, well, if the evidence and the law justifies it, can you allow for hundreds of thousands of dollars, if not millions of dollars, for a life-changing forever injury? And I'm just talking to them about it. And then the defense lawyers, there's 2 defense lawyers, they get upset and they're like, wait a minute, why is he asking about millions of dollars? So they say, look, we're going to change our agreement. We're going to pull back our stipulation. We're not going to concede liability. The only way we concede liability is if you agree to cap everything at $1 million, which is our policy. So we say, wait a minute, you already did, but no, it wasn't on the record. So I said, let's go to the judge. So we go to the judge, and for whatever reason, the judge is like, yeah, they're right. They can take back the liability concession, and you can just do the trial on liability and damages. So I'm like, fine, let's just do it on liability and damages. But then we find out that these witnesses are really not available, and the trial judge is not going to allow us to question them by Zoom. She's only going to allow in-person testimony. So I said, because of that, because we could have lost liability without these witnesses, I said, fine, I'll agree to the concession. And then I did a deep dive with that former employee, right? And the former employee actually had, because he was the property manager, he had all the policies. And he's like, look, these are all the policies. And they were from different insurance companies. And we went through every policy. And there really was only $1 million in coverage. There was no excess or umbrella, because the other policies were for different periods. So this happened in 2016, and the other policies were like for 2017, 2018. They were not applicable at the time of our fall, at the time of our injury. So, they were right. So I said, fine, we'll cap it at $1 million. You concede liability. So then we finished picking the jury. And also, like, while we're picking this jury, like, for no reason, they would, like, run to that judge, because they know that judge was a little bit, defense-oriented or whatever. They keep running back to the judge, And they keep saying like, oh, we want to cause challenge this juror. Like, there's no reason to challenge the juror. Like, the juror is completely fair-minded, but, you know, they're saying, well, they had an experience, they got hurt. Well, you know, people get hurt sometimes. You can't, you know, get rid of jurors for that. You can only get rid of a juror if they cannot unequivocally state that they will be fair and neutral and, you know, fair to both sides. Kind of like if it's a race, if one, you know, juror says, look, you're starting here, but the defendants are starting here, or vice versa, then you can get rid of them. But you can't get rid of them just because they happen to have like a car crash when they were like 12, or, you know, now they're like 50. What does that have to, but they're getting rid of these jurors. But like, I'm like, fine, you know what, I don't even care. So I just finished picking the jury, we get assigned a judge, and it turned out to be a fairly quick trial. Picking a jury took 4 days, then we get assigned a judge. And the trial itself took about a week. We started on Monday, and then we finished on Friday with closing arguments. So what happened was Tuesday morning, we actually did openings. And I wanted to use slides, you know, I wanted to use visual aids and demonstratives in my opening. I had everything set up. But the judge, again, for whatever reason, was like, no, you can't use any slides, only evidence, but we don't know if this will be evidence. So basically, you can't use anything. So I was telling the story of the injury, and I think it was something very interesting because she told me I could not use a slide, because I had a whole slide, because my doctor, that expert that I just talked about, what he did was he found that my client had a mild form of what's known as complex regional pain syndrome, CRPS, also known as reflex sympathetic dystrophy. That's a very serious injury. What basically happens is your brain, well, she had it in her left ankle, right? So at the site of the injury, at the left ankle, there's like a pain impulse, and that pain impulse gets sent up to the brain. Then all of a sudden, the brain processes it, and then the brain sends that pain impulse back to the sympathetic nerve system, which are the sympathetic nerves in your spinal column, and you have nerves branching out to your entire body. So it's like a tree, right? You have the big nerves, and then they become smaller and smaller, like when you see the little tree branches with the little leaves, the little twigs that kind of break off. So that's where she had the injury, right? She had the injury in her leg in what's known as a small fiber damage. But that's where you feel pain, right? So if I take a pen and I poke myself, that's the small fiber nerves that are gonna feel it, right? So she had it in her ankle. So what happens is it goes from the ankle, the place where you're injured, to the brain, then back to the sympathetic nerves. Then it goes into what's known as the the vascular system, the blood system, and then the blood system where you have your, you know, obviously your blood is flowing, but then you have nerves there too, the little nerves, everything gets inflamed. And then from there, it goes back to the site of the injury, right? That's where she feels the pain. And then it goes back to the brain again. So it's like a cycle. So I had like a chart. It was just like a basic chart from a doctor's website showing how the cycle works, how this chronic regional pain syndrome works. And the doctor's like, no, you can't use that. So you know what I did? I said, look, the injury, they had like this podium. I didn't use the podium. I just moved the podium out of the way. I don't like using podiums. So I like to be, you know, with the jury, kind of like open, like, you know, like here I am. I don't want anything blocking me. So I said, the podium is the ankle. And it was just standing there, you know, on the side. And I said, the podium is going to transmit the signal to the bench, right? The judge became the brain of the entire courtroom. And I said, then the brain is going to send it back to the sympathetic nerves, and which I said are the chairs where all the jurors are sitting, 8 jurors. Your chairs are the nerves. And then you guys, the jurors sitting in the chairs, are the actual blood vessels, right? Next to the nerves that are going to get inflamed and you're going to spasm. And I, you know, so they kind of felt it, right? It was like palpable. I think that's actually better than using the slide. And then I said, and now, like imagine these nerves are all being spasmed and you're being spasmed, right? Because of this. And now it's going to get sent back again to the brain and it becomes a cycle, a never-ending cycle. So I thought that was good. That was an opening. And so then we called our plaintiff first. Usually I don't like to call the plaintiff first. I like to call the doctor first, but we couldn't get our doctor. He was unavailable. So I had to call the plaintiff first. She testified, I thought, very well. And then we called the doctor. The doctor did pretty well. He was a little bit like going off on tangents. He's just like very smart. He was like Elon Musk doctor. He was just talking and talking about all this stuff. Like I tried to keep him on track. I'm like, doctor, just tell us about the injury. But he was very good. And then they had only one witness who was their doctor, the defense medical examiner. And we had a lot of dirt on him because he's like a professional witness. He testifies a lot for like 26 years. He only testifies for defendants. He always says that the defendants are, you know, the person who's bringing the lawsuit is never hurt. They never have any neurological injury. And I actually had judicial opinions quoting him. And it was funny because the judicial opinions always quoted him, and it was always the same. It was like, no neurological injury, no neurological disability. It's always the same. I'm like, how could it be? For 26 years, no one's ever been hurt. And I had like 7,000 reports that he did. So I thought that was powerful. And then, so we closed up. So in closing, the defense, they said, look, give this lady, you know, it's just a scar. There's no nerve injury. This whole thing with chronic regional pain syndrome is all baloney. They're making this out to be a catastrophic injury, and it's not. So give her $25,000. So I get up there and I say, look, this case is about personal responsibility. And they actually did something that I thought was a little bit like, I thought it was a mistake, but maybe, you know, what they had said in their opening is, we accept responsibility because, you know, we conceded liability. So we accept responsibility. And I said, wait a minute, what is accepting responsibility? What is the definition of accountability? When you take ownership of something, like for example, if I have, you know, a boy, and the boy's playing in the backyard, and all of a sudden he throws a baseball and he breaks a window. Is it enough to just say, look, I broke your window? Is that taking responsibility? No. I said full responsibility means three things. Number one, you have to say that I did it. Number two, you have to apologize and say, I'm sorry, I'm not going to do it again. And number three, and most importantly, you have to pay for it, right? You have to make it right. You can't just break someone's window and then go arguing, oh, you know what? It's not really broken. It's just a hairline crack, which is essentially what they were doing, right? Because they're saying my client is not hurt. So I said, that's not ownership. You have to take ownership for what you did, right? If you broke it, if I go into a store, I break something, then I bought it, right? I don't get a discount. I have to pay the full equal trade dollar value for all the harms and losses, right? Everything that was taken away from my client. So that's what I argued in closing. And I thought it was powerful. And then the jury comes back, you know, a few hours later, they're deliberating like all day. And then finally, like at 2:30, almost 3 p.m., they come back with a verdict. And so for the past, from the date of this incident, right, which was in July of 2016, 7 years ago, they give us $35,000. And when I heard that, I'm like, oh no, $35,000, that's really low. They said 25, the defense said 25. So I'm like, this is bad. We're not gonna get a lot of money. But then for the future, because this girl is 19 now, right? And she has 61, almost 62 years of future life expectancy according to the pattern jury instructions. So for the future, they gave her $500,000, $500,000. So the total verdict was $535,000. So I was like, yeah. And she was so happy. She was actually, you know, pretty much okay with the $85,000 offer. She thought that was a lot of money. We had to like kind of explain to her that we thought you shouldn't take the $85,000, which she agreed with, but you know, she was pretty much okay with the $85,000. So when she heard that, she just started crying. It was just really powerful. So we're so happy that we were able to make a difference in someone's life and get that kind of life-changing money for her, because it really was a life-changing injury for her. And so, but the thing, you know, maybe I'll do another video and I'll talk about all of the defense tricks, because there were so many tricks. First of all, they're like, we're going to concede liability. And by the way, everything is on the eve, right? On the eve, on the 11th, now it's usually the 11th hour. Everything is at 11:59 with 59 seconds, trying to surprise us, right? We're going to concede liability. So now, hey, do you have your doctor? If not, you're going to get dismissed. You know, all these little tricks. Oh, you can't go and do the full trial, right? Because what if we don't think it's $1 million case, but if you hit for like more than $1 million, well, then I have to get a private attorney to represent my owner, right, of this manufactured home community. He has a right to get his own counsel. So they're playing that game, right? And the judge is like, okay, fine. And then they start objecting to evidence, even though we have like photos of the scar, you know, photos of the pipe. No, you can't use the pipe because we conceded liability. But it's that's what caused the injury. We can't show what caused the injury. And it's interesting because the scar to the leg is exactly the same. It's like a moon, like a half moon shape, a crescent, as the pipe, you know, the broken pipe. Like, how could you not be able to show it? So the judge allowed us to show that. She allowed, of course, the photos of the injury, but they started objecting to like witnesses. We had like a circle of friends, community witnesses. They said, oh, you know what? It was exchanged a little bit late. You can't use those. And then they served a video to try to show that our client was doing all these activities like performing sports and doing all this surfing activities and not really hurt. So we actually did motions in limine, so we got that excluded. But it was interesting. The whole trial was interesting. But I really think that, you know, the overall theme from this trial, from what I saw, is that it's not really about the truth for a lot of these insurance companies, what it really is about is doing whatever they can to save their money. Wow, they love money. They're corporations, you know, they want to save that money. They offer you money like 100,000, and we say, okay, 120. Why? Because they know by giving you 120, guess what they're saving? Well, they're saving 880, right? The 880, the rest of the policy is safe and secure. It's all about like being really, really, you know, financially smart and saving their money. They're getting like 2 defense lawyers to fight it. You know, all these things like objections to this. But I think it really hurt them. And the other thing that I did, which I think a lot of lawyers should do, is like reach out to former employees of the company, because, you know, obviously the defendant himself, now the guy's like in his 80s, he was also out of state. I don't know if he even would have been able to come to trial, but he was going to sing, you know, obviously the company line and say we were safe and everything. We had all this dirt on him, but we don't know if we could have gotten it in because, like I explained, a lot of the witnesses weren't available. But basically, get these former employees, because they could be invaluable. These former employees, people who used to work there, are going to tell you the truth. And then, you know, they're not really expensive. You can find them on your own. There's companies that find them. There's one company I know in Atlanta called Strategic that'll find it for you. They're a little, you know, a few $1,000 you have to pay them, but they'll do the legwork for you. But you could also do it yourself. Like, it's not really hard. Like, I just did a Google search and the property manager's name was all over Google. So I just like, you do like a quick search, like TLO or whatever, you find them. Or sometimes you can find people through Facebook, whatever. And then just give them a call. And he's like the sweetest guy. He's like talking to me for like an hour, like texting with me. He's actually, you know, asking how the case is going. He was actually upset when I told him they conceded liability. He's like, oh, so I can't testify. He was ready to go. He was ready to testify by Zoom. So that's number 2. And number 3, whatever issues there are, just front it. You know, don't like be afraid of your issues. Be vulnerable and just front it. What I mean by that is just like tell everything up front. Like, for example, my client did not have much medical care, right? She went to the doctor, like I said, 2 or 3 times to the hospital, no treatment at all. Then all of a sudden she goes to one doctor for like an hour. He says everything's normal. And then my expert, which is obviously like my expert, right? I'm the plaintiff's attorney. So what did they say? They said, well, this is all attorney created, right? This is all false. So my counter to that was just like the true human story, that this was a girl, unfortunately, like her parents got divorced. She was living a lot of the time by herself. Her mother wasn't really home that much. Her mother was working. Her mother, you know, maybe had other boyfriends, was even living with those other boyfriends in other places where the girl was left by herself. You know, sometimes the girl would live with adults, like a former boyfriend of the mother who, you know, the girl didn't even know this person. So she was kind of left alone. So I said, this is a case of like isolation. And do you expect a girl who's like 13, just turned 13, to start, you know, navigating medical insurance, getting her own coverage, being able to call and make appointments and go to doctors? No. So the jury understood that was the truth. We fronted it. And that's why the lack of medical care didn't really matter. And we were still able to get $535,000. So we were really happy with this verdict. And, you know, the other thing was we worked really hard. Like, I was getting up at 5 in the morning every day of the trial. I was going to the gym. I was like lifting weights, doing a little cardio. Then afterwards I was driving to court. The hardest part of the trial for me actually was getting to the courthouse. It was like, even though it's so funny in New York City, I live like 14 miles from the courthouse. So you would think 14 miles. It took me an hour and a half with traffic just to get there. I probably should take the train next time. I was trying to drive there because I had all these trial bags and demonstratives and, you know, screens and all this stuff. But I thought, you know, we did really well. I was happy with the result. And what I wanted to say was that, you know, even though we worked so hard, like 5 in the morning getting up, and then sometimes I would work till like 1 in the morning at night to just try to get everything done. But it wasn't really work. It was just like, I just felt like almost like an inner energy. Like, I want to do this. This is fun. I want to help this person, because we really feel the love. Once you get to know the person, you really feel the love for them and you really care and, you know, you really give it your all. So it's just so much fun. And so I'm just ready for the next one now. The next one, we got to get over 1 million. That's our goal. So, yeah, so basically let us know what questions you have, but I think maybe I'll do another video. And I actually have all my slides. So I had slides that I prepared for opening statement, as well as slides or demonstratives that I prepared for closing argument. And I think they're very interesting. And even though this judge did not let me use them, I think having them was powerful. And I had my little tablet, my iPad. And so I looked at them and just, you know, that was like my notes. I didn't have any like actual notes, but looking at that, it was like boom. And it would make my opening flow and kept me going. So yeah, so I hope this has been helpful. Let us know what questions you have. and we're happy to answer them and do any other videos. But I really think that, you know, and the other thing I really learned about this trial is this entire injury, right? Because I wasn't really so familiar with chronic regional pain syndrome. And so I did a little research. Actually, one of the places that I found a lot of great resources is YouTube. There's like somebody on YouTube that has a channel all about CRPS. And so I watched that channel, and she explained that this is a very serious disease. This is known as a suicide disease. People are killing themselves because the pain is so bad. And on the McGill pain scale, which is like a pain scale that is used in research, that is the most painful disease, CRPS. It has 46, which is, you know, more than even like childbirth is like, I think a 37, but this is like a 46. This is the most painful thing you could have, this chronic regional pain syndrome. So I learned a lot about that. So now I'm like well equipped, I feel like, because with this expert who's an expert, a neurologist who's an expert in CRPS, I had him. And I feel like now I could do like another CRPS case. And I actually watched webinars of other CRPS cases from Trial Lawyers University and other resources. And I saw that other lawyers were getting ridiculous numbers. Like there's a lawyer out in California who got, I think, 8.4 million on a CRPS case. There was another CRPS verdict for like 12 million. But I mean, these are more serious. So that was actually my response when they said, hey, you're saying this is a catastrophic injury. Meanwhile, it's a 2-inch scar. I said, no, but look, she's 19. She has some of the symptoms of CRPS. The doctor says that because of the nerve conduction testing and the temperature, that it's starting, but it's just beginning, right? And then later when she's 50, when she's 60, she may have the full-blown CRPS, which is when, at that point, she may have much more of a serious injury. So that's why we asked for a large amount. We asked for $1 million and we got 535, which I thought was pretty fair, you know, pretty fair from the jury. But the whole experience overall, I really enjoyed it. It's, like I said, it's a lot of fun. I don't feel like it's work. When you do what you love, you're not really working, and I'm just ready for the next one. Okay, thank you so much. Let us know what questions you have, and we'll do another video maybe going through the slide deck, because I thought the slide deck is interesting because it doesn't really only apply to this particular case, but it really applies to like all cases, because it kind of applies to a lot of the arguments that you see in almost any kind of case, whether it's a car crash case or a, you know, slip and fall. It applies across the board. And what it really shows is it shows kind of like how to deal with the defense. When the defense gives you this, then what's the best way to respond? So I'll go through that in another video. Okay, everyone, thank you so much. Have a great day, and we are here for you. Okay, bye-bye.